Welcome, first of all, to Landmark Chambers Inquiry Law webinar series. This is the second session in which we're going to be dealing with issues of evidence. We're delighted to see so many of you joining us for this session this evening. We hope that you will find the presentations and the discussion both useful and informative. My name is David Blundell KC, and I'll be chairing the session today. I'm joined by my colleagues Fiona Scolding KC, Chris Jacobs and Katharine Elliot. I'll introduce each of those a little more formally in just a minute. But to begin with, can I take, as we say at the start of all legal proceedings, a few housekeeping points, if I may. First of all, your microphones are automatically muted, so you don't need to adjust your local settings during the course of the webinar. Secondly, and importantly, we very much welcome questions throughout the session. Please submit them via text in the Q&A section, which should be found either at the top or the bottom of your screen. If you'd like to remain anonymous when asking a question, you can do that by making sure you tick the box "Send anonymously" before submitting your question. We'll endeavour to answer as many of your questions as possible at the end of the presentations, the end of the webinar session. The webinar, I should tell you, is being recorded, and you will receive a link to the presentation and the recording shortly after the event concludes. And finally, if your connection is lost at any time during the course of the webinar, we'd invite you to rejoin the meeting by clicking on the original link once more. So, with that short introduction, let us begin, and let me introduce, first of all, my colleague Fiona Scolding KC, who's going to be taking the first of the sessions today. Fiona has enormous experience in the world of public inquiry. She's appeared in very many public inquiries over the course of the last 10 years or so, both as counsel to the inquiry and for various core participants, both individuals, charities, professional organisations, central government and other public bodies. Amongst the long and impressive list of public inquiries that she's been involved in are the Independent Inquiry into Child Sexual Abuse, the Infected Blood Inquiry, the COVID Inquiry, the Thirlwall Inquiry and the Lampard Inquiry. So with that introduction, Fiona, over to you.
Thank you very much, David, for that kind introduction. I am going to talk to you, and could I ask that we go to the slides, please, about privilege and public inquiries. I'm going to talk to you about when privilege applies, what the parameters are of such privilege, and if and when you should waive privilege. Next slide, please. So the chair of any public inquiry has the power, in effect, to compel you to provide either evidence or documentation pursuant to Section 21 of the Public Inquiries Act 2005. They will usually ask you nicely under what's known as a Rule 9 request, but then if you say, no, we're not going to give it to you, they have the power to compel you. However, there is the exemption under Section 22. And what Section 22 basically says is that someone doesn't have to give or provide any evidence or document if they couldn't be required to do so within civil proceedings, or the requirement is incompatible with a retained EU law obligation. Now, I'm not going to bother with the EU law of what's a retained or non-retained EU law obligation. I don't think that's going to be particularly relevant, other than maybe issues to do with competition, if there is a public inquiry which deals with those sorts of issues. As well, under Section 22, it preserves the right for public interest immunity, which is a sort of common law right, in effect. So when do you fall under Section 22 of the Public Inquiries Act? There are broadly 4 or 5 different circumstances in which you and your client can claim we are not giving you this. Firstly, if there is a duty of confidence. Now, my view is there would be few circumstances in which the duty of confidence would override the public interest in handing over material in reality. However, what usually happens in those circumstances is if the material is subject to the common law duty of confidence, as I have identified, if we could go to the next slide, please. If it's subject to the duty of confidence, then it may well be possible for you to say, and in fact it is possible for you to say, you can only have it if it is compelled. There is a case where a public inquiry was asked to look at this, which was a case involving a non-statutory inquiry concerning nuclear testing, where the health records of people who had died subsequent to the nuclear testing, although potentially not related to it, they were asked to be gathered by the inquiry, and there was an objection to it. And the court found that the public interest was upheld by allowing the disclosure of those medical records, noting that medical records remain confidential even after someone's death. Another example of where you could have confidential material which doesn't have to be handed over is religious confidence. But again, as there is an argument about whether or not the duty of the confessional is or is not absolute, which is not agreed upon in terms of religious the Church of England doesn't agree on what the position should be in any event. I think there would be circumstances where this confessional would ask to be broken. The most likely circumstance in which you may well be able to plead a common law duty of confidence and the inquiry say okay would be journalistic confidence. Certainly in respect, for example, a number of public inquiries come to light after, for example, documentary material. You think about the Afghan inquiry that's going on at the moment, the Brookhouse inquiry, all of those, and some of the concerns came to light as a result of undercover material or whistleblowing material that was given to journalists. And the inquiry will obviously have to balance the public interest of journalists to keep their sources private versus the public interest of having, for example, material which was not the subject of broadcast. I've certainly been involved in that situation on a number of occasions. And usually what happens is you and the broadcaster negotiate what, if anything, you can see, and then what, if anything, you can broadcast, and the broad parameters of freedom of expression versus the broader public interest in ensuring that these matters come to light. But journalists will zealously guard their right not to disclose their sources, to the extent that some of them will go to prison as a result of it. But you can usually negotiate that. Next slide, please. The next obvious example is legal professional privilege. As we all know, there are two forms of privilege. Firstly, litigation privilege, secondly, legal advice privilege. And you don't have to hand over the document at all. I mean, there might be some circumstances in which the inquiry might want to see the underlying privilege material, but my view is you're entitled to say you're not entitled to see it, even to see whether or not it's privilege. I've just done a little handy checklist about when litigation privilege applies. It's usually not that difficult to identify. So my little handy checklist is 5 in nature. So firstly, is litigation in reasonable prospect? That means adversarial litigation, however, not internal investigations, and it has to be more than a mere possibility. So simply saying it might be possible for someone to possibly bring a claim against us at some point in the future that we're not sure about, and we're not really sure where, why, and what, would not be sufficient to have you covered by litigation privilege. If, on the other hand, you, for example, were representing a pharmaceutical company and they were to ask for advice on potential claims under, for example, negligence or the Consumer Protection Act, that would plainly be covered, even if no such claims were in prospect at the time in question. Was the document created for the dominant purpose of the litigation? That has to be not for the conduct of litigation generally, but a specific piece of litigation, but it does include avoiding or settling litigation, i.e. dealing with things at the pre-action or whilst you're undertaking them. And then, so that's, if those two matters are met, then legal professional privilege applies. But what you also have to think about, and this is particularly the case if you're representing large organisations, whether that's the government, local government, public bodies, or large companies, where material tends to go all over the place, thanks largely to the wonder of email. So you can't necessarily identify or that the material hasn't been sent to third parties, for example, who are not part of the client group. So what you also always have to ask is, have you forwarded this to anyone else beyond those originally involved? If so, who and why? Does the recipient have a common interest in the subject matter? So if they are part and parcel of the organization and, or for example, their companies and it's a shareholder of the company, or it's an insurer, or, arguably even sort of PR people who are advising you about those issues, and it was disclosed on confidential terms, then it will maintain its privilege. What unfortunately you often find is that even material which has been subject to litigation privilege has been sprayed around various individuals without identifying that it is confidential, and you can then run into difficulties where in fact you have inadvertently waived professional privilege, and therefore you have to hand it over to the inquiry. Now, legal advice privilege has historically been more complicated to determine and has been the subject of a number of cases over the past 10 years, including, most importantly, the Serious Fraud Office and ENRC case. I mean, that and Three Rivers DC seem to have, over the past 30 years, occupied more court time than I think practically any other set of cases. So the general rule is this communication between a lawyer and a client? It includes an in-house lawyer, but not an in-house lawyer if, for example, they're acting as part of the senior management team. So if the in-house lawyer is acting, for example, as a member of the board or one of the trustees, that does not mean that your in-house lawyer, anything that your in-house lawyer sends to a client is therefore subject to legal advice privilege. Trainees, paralegals are also considered to be a lawyer. A client is limited to those seeking and obtaining legal advice. So it's not everyone. You have to be really careful when you're looking at this about who was the advice sent to, who is it meant for, and it's only those group of people for whom privilege can be claimable. It's not included in particular, and this is what the SFO case says, is those who are authorised only to provide information to the lawyers. So if, for example, you've got an internal investigation into wrongdoing and one of the lawyers is asked to collate information about that wrongdoing, the collation of that information is not subject to legal advice privilege, although the advice the lawyer then gives will be. So that's something I think you particularly have to look out for. And I'm particularly thinking about central government and large organisations in that respect. Communications between a lawyer and a non-client employee will not be privileged unless they are subject to litigation privilege. And the basic things you need to consider is who is advising, who is the client, and again, what has happened to that information subsequent to the legal advice privilege being created, if you think that you satisfy the test. The other issues to look at is, was this legal advice for the dominant purpose of giving legal advice? So it's not just, saying to a lawyer, what does Section 2 of the Inquiries Act says? It's also what should be done in a relevant legal context. So it includes exchange of communications and to keep client and lawyer informed that advice and support should be given as required. And it could also be partly privileged if some or all of the evidence was a privileged communication. I think we're all familiar with board minutes, or, for example, minutes of meetings, or if you're representing central government clients, often as part and parcel of submissions to ministers, there will be part of it that will contain legal advice and part of it that will not. And there are the same rules as for litigation privilege in respect of post-creation privilege. Inquiries often ask lawyers to consider waiving privilege. Of course, we all have to remember that the privilege rests with the client and not with the lawyer. I think some examples of where privilege was waived, and therefore you can see some really interesting discussions, both in the evidence and the report, as to why people advised in the way that they did, why they determined that things were reasonable or not, why things were settled, are both in the infected blood inquiry and the post office inquiry, neither of which in reality could have properly fulfilled their terms of reference without waiving of privilege. So you're going to have to carefully consider with your clients if you are asked to waive privilege in that context. The other thing to be pleased about is in the Three Rivers case, although the Three Rivers case has been doubted by the SFO case in 2018, but nothing's gone to the Supreme Court. I think everybody thought the ENRC and SFO case might go to the Supreme Court, but it didn't, is that what the House of Lords, as it then was, did say is that presentational advice by the bank's lawyers would be legal advice privilege if it was about advice about possible criticism, either for the organisation or for the individual in respect of an inquiry, whether that's a coroner's inquiry, a statutory inquiry, or an ad hoc inquiry. And those skills, and the House of Lords says something nice about lawyers, saying that the skills of professional lawyers are needed when advising at an inquiry, and how to present yourself at an inquiry are legal skills for the purposes of legal advice privilege. So the advice you are giving to clients about how they craft their evidence, about possible criticisms, I would suggest are covered by legal advice privilege. Now, the next area is public interest immunity. It relates to documents almost exclusively central government, police or intelligence service documents, because there is a real risk of serious harm to an important public interest. Obvious examples that you can see would be national security, diplomacy or undercover police information. But the inquiry is allowed to see those documents, or in the vast majority of cases, it can see those documents, but it often sees those documents in closed material proceedings. Now, this inquiry is not enough in terms of next slide, please. Sorry, this is my fault. I'm going ahead of myself. What usually happens in those circumstances is you adopt a closed material proceeding, as you do in civil cases. Mr. Blundell, the chair, is one of the experts in this country about closed material proceedings, so I will leave him to discuss that issue. But it's fundamentally exactly the same as happens in civil proceedings, in that there may well be a closed hearing at which the issue of public interest immunity is discussed and determined by the judge. There are two other matters that I should identify. Firstly, the privilege against self-incrimination. So that's either in respect of criminal or civil proceedings. And I would ask you to sort of read the slide as far as that's concerned. There are some complexities about when something goes over the line so that it is directly or indirectly. If it directly incriminates you, it's obvious. It's the indirectly incriminating that can be quite difficult, in terms of, is this something which is going to lead to a line of inquiry which is then going to lead to prosecution? In circumstances where the privilege against self-incrimination is going to mean that people are not going to give evidence, or will just say, I can't say anything, what usually happens on a practical basis is the inquiry asks for an undertaking from the Attorney General, so that the evidence given in the public inquiry cannot be used by the police in respect of any criminal prosecution that then takes place. And that's sometimes why public inquiries take place after criminal proceedings have been discussed and covered, because then you don't have to worry so much about that. Although it is always an issue when there are allegations of criminality, and there are nearly always allegations of criminality raised. Whether or not they are sufficient to bring a reasonable line of inquiry is another matter. Last but by no means least, could you please put the next slide up? Privilege against right, and then the next one, please, is parliamentary privilege. Now, I have a particular loathing of parliamentary privilege because it causes all sorts of practical difficulties, not just in inquiries, but also in running public law proceedings. What it in effect means is that debates or proceedings in Parliament ought not to be impeached or questioned outside Parliament. The position at the moment is it has never definitively been decided by the UK courts that that a public inquiry is covered, so that parliamentary privilege covers public inquiries as well as court proceedings. But both in Australia and New Zealand, there has been a finding that that's the case. Could you put the next slide up, please, Hilary? So what that therefore means is you often can't, when you're providing evidence to inquiry, directly refer or say, if, for example, you're a government minister, you're not able to put in your witness statement, I went to Parliament on the 15th of March, and this was the question that I was asked, and this was how I answered it. What usually happens in practice is everyone says, well, look, we think that parliamentary privilege may apply. And if you try to say that it doesn't apply, usually Speaker's Council gets very cross, and you end up having lots of discussions with the parliamentary authorities about what the position is or not. And you then end up with quite an artificial situation where you give exactly the same material, but you don't say you told the Houses of Parliament that at the same time. I mean, my view is that public inquiries should not be the subject of parliamentary privilege, largely because you're very often looking and examining what people said in Parliament, whether they told the truth, whether they didn't tell the truth, whether the information given was sufficient, whether it was insufficient. And this rule in respect of parliamentary privilege, while I completely understand it in a court context, does seem to me to be pretty inimical to the effective working of a public inquiry, which, let's face it, has been set up by the executive very often. So that is the end of my slides. Thank you very much for listening to me, and I apologise for going slightly over to Katharine and David. Thank you.
Thank you very much indeed, Fiona, for that fascinating talk. I particularly enjoyed the material you were covering towards the end on both closed material procedures and parliamentary privilege and so on and so forth. Maybe we can discuss that a little bit more later on. And certainly I would share some of your concerns about how, in practice, issues around Article 9 and parliamentary privilege can have a really derailing effect, I think, on proceedings and make them very difficult indeed to progress. So thank you for that. So we will move straight on to our next presentation, which is by Katharine Elliot. Katharine is one of our fabulous juniors in Chambers. She practices across the full depth and breadth of public law, and having worked with her on a couple of cases, I can vouch for that. She advises and represents clients in human rights cases, immigration, court of protection work, and community care matters, up to and including successful appearances in the Court of Appeal, something I'm not terribly familiar with. She's regularly instructed in inquests where Article 2 is engaged. And again, I can vouch for her work in that field, as I roped her into writing the Article 2 bit of a forthcoming textbook on human rights that Landmark Chambers is producing. So that's a bit of a push for the book here. And she also acted as counsel to the Dame Linda Dobbs review into the HBOS Reading fraud. So Katharine is going to be talking today about the proposed Hillsborough duty of candour reforms. Katharine, over to you.
Thanks very much, David. And I should say it's lovely to see some familiar faces on the attendance list, or rather familiar names, as I can't see any of you, but welcome everyone. So in this session, we're going to cover the following topics very briefly. Duty of candour as it exists in the judicial review context, because that is the model that has been pushed as a way to resolve some of the problems around disclosure in judicial review proceedings, obviously, but also in inquests and inquiries potentially. We're then going to look at the case for reform, so why we're having this conversation. We're going to look at past proposals for reform. We're going to touch briefly on where we are now. I have to say from the outset that by this date, we should have had the draft bill of the Hillsborough law. It was supposed to be published on the 15th of April 2025. So this talk would have been wonderfully timed, but unfortunately, we're still sort of twiddling our thumbs and waiting for that. So that will be very brief. And then we will look at, in the absence of the actual bill, some points for thought on what issues might come up as and when the draft is actually put before the public. So very briefly then, the duty of candour. As I mentioned, it's a judicial review concept. I've put under defined in different ways a variety of cases which are often cited as a way to sort of encapsulate what duty of candour actually means. Partly it's about disclosure of information and documents which are relevant and necessary to ensuring that the court has before it the full picture, evidentially, as to why the decision under challenge was made. Put another way, it's making sure that the court and all the parties have all the information or documents which support or contradict each party's case. And if you're a defendant, volunteering information which might identify other grounds of challenge for the claimant. It's also described as full and frank disclosure. And put another way, very pithily in Huaro, it's about identifying the good, the bad, and the ugly. So not just what you want to rely on, but also on the stuff that you frankly might find quite embarrassing if you're the decision maker in question. But it goes beyond just shoving the documents and the information into the proceedings. Duty of candour is also about the content of your witness statements and your submissions, identifying relevant information and explaining it so that not only the court but also the other parties understand its relevance to the decision and can use that information for themselves. And obviously the decision maker can use it to properly decide the case. So it's more than a dump and run of files and run away. It properly done, a duty of explanation as well as a duty of disclosure. It's a high duty to assist the court in reaching its decision, and it operates with particular force when you're looking at proportionality assessments, particularly in the context of any alleged breaches of the Convention for Human Rights. It is very often focused on in the context of defendants, because defendant decision makers, by virtue of their role, will often have the most information, and they are very clearly expected to turn up with their cards on the table. However, it's very important to remember that claimants are not exempt from duty of candour obligations. And as in the case of Khan, which I've put on the slide, if you are a claimant and you do not comply with candour, it can have some quite serious consequences for you as well. Underpinning the duty of candour, and a central sort of principle of it, is that duty of candour is appropriate in judicial review, because judicial review proceedings, even though we're the Crown on behalf of versus the defendant, it's not supposed to be adversarial. It's supposed to be a checking by the court that the rule of law is being upheld by the decision maker. And so an excessively robust approach to defending a claim, even where that's done in good faith by whatever party, can compromise compliance with the duty of candour. So being overly defensive, and the case of the High Court in the case of RHM made that very clear. So you're not supposed to see this as part of an adversarial defence exercise or a prosecutorial claimant exercise. It's about assisting the court to make sure that the rule of law is upheld. As Fiona's touched on LPP and PII, I won't go into those, but there are obviously exceptions to the duty of candour which apply in this context. And duty of candour is a continuing duty. It lasts throughout JR proceedings. For defendants, there's also having to be aware that a decision might be challenged and that your duty of candour might kick in slightly earlier than that. And that's the case of Huaro. And very importantly, given some topics that are going to come up in the reform section, the consequences of breaching the duty of candour do not involve direct criminal sanction. They can include the drawing of adverse inferences. So you didn't disclose this information. Why? It might call into question the decision that you've made if you're a defendant. It can result in adverse cost orders if there's been a waste of time in trying to extract the information from you. And you can end up in contempt proceedings, which obviously at the worst can result in some criminal sanction, but there's no direct criminal sanction biting directly on breach of duty automatically. And a breach can be unintentional in the duty of candour context at the moment. So even if you didn't mean to do it, it was just inadvertence, you can still face the music for a breach. So that is the background duty of candour concept, and that is the framework that people have chosen to talk about reforming disclosure by the public sector. So why are we talking about reform then? Because as you've seen, we've got duty of candour in the judicial review context, and Fiona touched earlier on the fact that we have disclosure regimes for public inquiries. We also have disclosure rules in inquests. So why are we talking about this? Effectively, two reasons. The first is there have been lots of problems with duty of candour, and the sheer number of cases on my previous slide will have indicated that it's a very litigated concept. it's unclear, it's complicated, it's a common law concept, so it's not nicely defined in statute, and it pulls lots of different threads together. So it's criticised for those reasons. And secondly, disclosure in the public inquiry context, and also to a lesser extent in the inquest context, has been increasingly criticised, the present state of affairs, because there have been identified past failures of candour by public sector bodies involved in, for example, the Hillsborough disaster, the investigations that followed that, Grenfell, Post Office. I put little dots there because the list genuinely does go on and on and on. But also there are increasing concerns that the amount of discretion for example, those leading inquiries or coroners in coroners' courts means that there's a fundamental lack of consistency between different types of public investigation. So, you know, if you're doing an inquest in Cambridge, the chief coroner there might have different ideas of relevance and ordinary disclosure expected from, for example, the prison service than someone in Manchester, and that is not fair, that there is that inconsistency. So there's all of this debate going on, and this crystallises in particular around the Hillsborough disaster in the 2017 report of Bishop James Jones, who was involved in the last review of those tragic events, and who was asked by then Home Secretary Theresa May to pull together a report basically looking at how failures of candour by public bodies had impacted Hillsborough survivors and their families, and the families obviously of those who sadly died. And at the same time, and very important for our current reform discussions, we had the Andy Burnham bill, which we'll talk about in a bit more detail, which was the first version of the Hillsborough law. So although we don't have the government's bill yet, we do have a bill which sought to put this into this reform ideas to crystallise them into possible legislation. That bill fell by the wayside because of the 2017 general election. There was no attempt to revive it after that. But in the King's speech after their coming to power, the Labour government announced that they were going to pursue a Hillsborough law as part of their legislative programme that would introduce a public sector duty of candour reform of the kind, although they didn't commit directly to it, that had been contemplated in the 2017 bill. Now, as I alluded to, we were supposed to have the draft bill by now. It was supposed to have been published on the 15th of April, which would have been the Hillsborough anniversary. For reasons that are not public in the sense that they've made an announcement, but there have been a lot of concerns about what the draft bill might have looked like, which we'll come on to in a moment. But effectively, it's been put back onto the draftsperson's table for now. So we wait to see what happens with that. But that's how we've got to the reform discussion. Past proposals then. So we have the Andy Burnham bill, which was called the Public Authority Accountability Bill, and it drew on an existing duty of candour reform in the public sector, which specifically directed itself at the NHS, and that has been in place since 2014. And I've put the relevant regulations on the slide. And effectively, what that does is it imposes a duty to act in an open and transparent way in relation to care and treatment provided, and specific obligations kick in about notification and the provision of a factual account and an apology in the event of a notifiable safety incident in respect of care or treatment. And importantly, it operates alongside other existing professional regulatory frameworks. So, for example, by the GMC, GDC, NMC, and it's also enforced by criminal sanctions. So it took that largely as a model. But the intention of the bill was very clearly to expressly to widen and strengthen existing duty of candour principles as they applied in JR, and apply them in context far beyond that, as we'll see in a moment. I should also note in passing that a similar duty of candour to the type proposed by Andy Burnham was proposed for police in particular via the Criminal Justice Bill, which also fell by the legislative wayside, and we're getting a theme here because of the 2024 general election. So going back then to the Public Authority Accountability Bill and looking at some of its key features, and to explain why I think this is an important exercise, campaign groups in particular, the Hillsborough Law Now group, have said very publicly recently that they consider this 2017 bill to be like the gold standard. So they want this law as it was proposed, and they are holding that up to the government and saying, if you fall below this threshold, we will not accept this and we won't be happy. So although this is not the draft bill that the government's currently working on, it is clearly informing the debate and the parameters of the discussion around reform. So let's get stuck in. It imposes two duties of candour. The first is a general duty on public authorities and public servants to act at all times in the public interest and with transparency, candour and frankness. So that applies at all times. And then most importantly, there's a specific duty to assist court proceedings, official inquiries and investigations which relate to their own activities or where their acts or omissions are or may be relevant. And that applies to both public bodies as entities and to all their employees and or agents. So it's not just targeted at public bodies, it's everybody who makes them up. And it also, importantly, applies to private entities and individuals in the same way who are exercising delegated or contracted functions, or where they owe their own health and safety duties to the public. So this is not just a public sector problem. It will impact relevant actors from the private sector who engage with health and safety or with public sector bodies in discharging their obligations. Clause 6.3 goes into a bit more about what that specific duty entails, but because of time constraints, I won't go into that. But the most important takeaway from the scope of this bill is that it applies wherever the public sector is involved by its acts or omissions in court proceedings. So any court or tribunal proceedings, civil, criminal, coronial, this is all expressly in the bill in clause 10. Statutory and non-statutory inquiries, so there will be no difference in the standard of the duty of care between the two of them. And it would include criminal and disciplinary investigation. So the police investigation would engage this duty of candour as well for public sector bodies. There's a grey area clearly in the bill around what happens where you are a public body acting in court proceedings or tribunal proceedings, but in a private law capacity. And the classic example in that respect is the employment law sphere. It's not clear to what extent it would bite there. And that's obviously something that will need to be taken forward in reform. There are exemptions for privacy, data protection law and national security of the kind that Fiona discussed earlier. It's enforceable by application for anyone impacted by the alleged breach prior to proceedings or the investigation. So effectively, it will be introducing the concept of pre-action disclosure, and then it would be during such proceedings and investigations by the decision maker in the normal way. And another key theme, it's backed up by the introduction of direct, immediately biting criminal offences for any breach that is intentional or reckless of the duties. And that is a general entity-wide liability, but also bites on any individual at any level. It also recognises the ability to assert privilege against self-incrimination, and that people involved in criminal investigations, so as suspects, will not necessarily be subject to this in the same way, although that is, again, a bit less clear. So where are we now in terms of the now? This bill, although it fell by the wayside in 2017, was looked at by the Joint Committee on Human Rights in 2023, and they endorsed it as an effective way to ensure that the UK meets its investigative obligations under Articles 2 and 3 of the Convention, which those who practice in inquests and inquiries will be very familiar with. And they also said that there needs to be reform because of all the problems I mentioned previously about adequate legal frameworks for disclosure in inquest and inquiry contexts. They also considered that it would have practical benefits for everybody involved, but particularly those funding inquests and inquiries, given how long they're going on, because it would speed things up. If you don't have to pull the informational teeth and documents out of public bodies or court participants or whoever, you might actually get decisions faster. And they cited the UEFA Champions League final, the May 2022 one, as an example of how that could come about. So that was a much obviously smaller independent review, but it delivered its report incredibly quickly compared to many similar sort of inquiries or investigations. And they also expressly endorsed the need for there to be criminal sanctions. The government responded to that in February 2025, recommitting themselves to introducing the public sector duty of candour. They did flag that they were worried about the impact of the duty as framed in the bill on self-incrimination, which Fiona spoke about, and also potential issues with Article 6 of the Convention. So that's free trial and procedural fairness, which they weren't entirely clear about, but that's clearly enough of a concern that they're talking about it publicly. Then there was an inquest report in April 2025 that followed a family listening today to discuss basically what families felt the Hillsborough law should do. And as I said, the upshot of that was that they want the 2017 bill model. But then we're now back at the drafting table, and as I alluded to, some people involved in this have seen a draft bill, because there has been a lot of reporting towards the end of last month following this inquest report that suggested that the draft bill that had been started, possibly with the aim of publishing it for the April deadline, did not actually even include a public sector duty of candour. And there was a lot of outrage, I think rightly so, based on the commitments that have been made by those who've been campaigning for this, about that, because the fundamental point of the Hillsborough law is that it has this duty of candour. So for now, we're back at the drafting table, and we wait to see when the actual bill will come through, because they've not given a time frame now. So very quickly, thought points for reform. So these are effectively questions and choices that the government is going to have to make, or maybe has already made, for all we know. So scope. Should it apply in adversarial court proceedings or not? So should we be talking about the duty of candour that is universally applicable, or should we just be talking about it in the context of JR, inquests and inquiries, where there is that underlying theme of, we're not fighting this, guys, you're helping me make a decision? How will it interact with existing disclosure regimes, which are present in all of those areas? So that's scope. Subject. Should it be public bodies and the individuals that work for them and their agents, etc., etc.? Rarely are mandatory statutory duties imposed on individuals because they give rise to strict liability. So that's a problem. If it is going to be individuals, should it be everyone, or should it only be those who are paid to take responsibility and there is a reasonable expectation that they would bear the responsibility for some of the decision making that they probably had a leading hand in? Also, based on that, should everyone be liable to the same duty or degree of criminal sanction? So even for the Hillsborough families, as flagged in the inquest report, they are clearly concerned about scapegoating of junior public servants, and this has been seen to be a problem in the past. And with that, they have asked whether there would be protection for whistleblowers as part of this. Then practical details. Duty of candour bedeviled by, when does it kick in? What does it look like? And so on and so forth. So should we have a model like the CPR, for example, that gives everyone certainty? How is this going to be funded? Because as Fiona outlined, and as we've gathered from my whip round through the duty of candour, this is always going to be complicated. People need legal advice to access it properly. Who's going to fund it? And there's a consultation by government on funding around inquiries and inquests at the moment. And then finally, my parting thought, should we even be talking about duty of candour at all, given how vexed duty of candour is as a concept in JR? And also, and this harks back to something Fiona said, are we genuinely in a non-adversarial arena now when we're in inquests and inquiries, bearing in mind criminal sanctions and civil proceedings are almost always in the background and will inevitably be informing strategic and other thoughts, such that maybe we should be looking somewhere else entirely? So having dropped that hot potato of thought, I will now draw myself to an end, because again, I think I've run over slightly, so apologies, Chris. But thank you very much, everyone, for listening.
Thank you very much indeed, Katharine, for that fascinating talk. I have to declare an interest in this. I've actually co-authored a paper with Katharine, although I think describing it as being co-authored may give myself rather too much prominence in the process of writing that paper, a paper for judicial review. I'd be really interested in exploring a couple of the issues around the duty of candour when we get to questions at the end. But thank you very much, Katharine. Fantastically interesting stuff. And so next we move to our final paper from Chris Jacobs. Chris has represented core participants in a huge number of public inquiries since 2018. He's another incredibly experienced public inquiry practitioner. Most recently, in January of this year, he acted for the Traveller movement in Module 4 of the COVID-19 inquiry, which dealt with vaccines and therapeutics. From 2021 to December 2024, Chris represented 156 sub-postmaster core participants in the Post Office Horizon IT inquiry. I think one of those inquiries which, above all others, has really captured the public imagination for a variety of reasons. And Chris has also represented core participants in the independent inquiry into child sexual abuse, as well as the Brook House inquiry. So a huge amount of experience across the recent inquiry settings. And so with that introduction, Chris is now going to talk to us about some work at public inquiries generally. Chris, over to you.
Thank you, David. I hope you can all hear me and see me well enough. If you can't, then let us know and I shall move closer to my screen. So I'm really going to talk about, if we could have the first screen up, please, Hilary. The first slide, I should say, on the screen. Practical matters, tools and tactics available to those directly impacted by the subject matter of a public inquiry. And I'm really talking about complainant core participants, sometimes referred to as victims and survivors, and how, if we're representing people who are affected by the particular scandal that's under consideration, can we best advance their position and their claims? The biggest tool that's available to lawyers representing complainant core participants and victims and survivors of scandals is disclosure, but that can also be the biggest problem. And I found a quote, I remember in July listening to Jason Beer saying this in the Post Office inquiry. This was about 5 months, just under 5 months before the evidence closed, and he said to the chair, "Your inquiry has disclosed to core participants almost 250,000 documents, totaling just under 2 million pages of documents. I'm told, for those wishing to visualize that number, that if stacked up, it will be the length of 2 football pitches." Now, to most of us, that is an impossible task to ever read anything like that amount of documents, even though you got from end of 2021 to the end of 2024 to do so. It's just not possible. So how do you get round that? And if we could go on to the next slide, please. The disclosure is published on a document review platform. The one that's most commonly used is called Relativity. That is available to legal representatives. When you act for core participants, you can apply for your given codes to access the platform. But only those who've signed confidentiality undertakings can access that platform. And the information can only be communicated to those who've signed confidentiality undertakings. Now, back in the pre-COVID days, when we were all seeing our clients face to face, it probably didn't really matter. You didn't have to think about, is the person I'm speaking to someone who signed a confidentiality undertaking? Am I breaching the undertaking by telling him what's on the what's not in the public domain yet or at all? And so nowadays we have big Zoom meetings with lots of clients. It's a very convenient way to talk to a sort of a cohort of clients. And you have to be absolutely sure that if you are referring to documents that aren't in the public domain, that have been disclosed, that everybody who is on the call has signed the confidentiality undertaking. You have to make it very clear to your clients that what you are telling them is something that they cannot share with anyone else who hasn't signed that undertaking, because if those undertakings are breached, the inquiry, they do find out about it, they do investigate, and the consequences can be serious. So you've got all this information, but you have to be very careful about how you disseminate it to clients. You have to be careful to ensure that your clients understand the consequences of having privileged information disclosed to them. If we go over to the next slide, then please. my tip would be, when you are faced with this huge amount of disclosure, look at the witness statements, those in particular, those who are going to be giving evidence in the inquiry timetable, and look at their exhibits. A lot of the disclosed material will just be data, much of it heavily redacted, but it's been disclosed as part of the inquiry process and it's put on the site. So the 2 football pitches isn't necessarily as bad as it sounds. But what I would suggest is those representing complainant court participants, victims of a scandal, should focus on what the objectives of their clients are when reading those statements and exhibits, because that will help formulate the questions that you're going to be putting to witnesses that give evidence, and will help you with your submissions. Now, I've set out a number of objectives that your clients might have, and I think it's important to understand that the inquiry doesn't necessarily know what is going to be important to your client, and that's why it's really important to understand what they want and what their objectives are. Many people who have suffered abuse, this was a big point in the child abuse inquiry, they want acknowledgement. They want to be heard. If you've been told for 20 years that you're making things up and that you're lying, the fact that what you say happened to you is acknowledged is a very important thing. It's empowering, and it can give a sense of catharsis. Apologies are enormously important. If you have an institution such as a church or a local authority who failed to protect, for example, a child in care, or an institution such as the post office, even Fujitsu, in the post office inquiry, getting that apology is an acknowledgement that a wrong has been done, and particularly if a person's reputation has been affected by what happened to them, it's enormously helpful. So restoration of reputation is again an important issue in relation to many clients. If we could move on to the next slide, please. There's a concept of restorative justice, which is very important when representing victims, because compensation is not the be all and end all of what proper redress should be. Very often redress goes beyond financial compensation. This was a big point in the Grenfell inquiry, and it's a point in the post office inquiry too. People might want counselling and support. They might want face-to-face meetings. They might want engagement with communities to restore their reputations. The bursaries for education of children who have been affected by what their parents went through is important. Support for family members, and then maybe a tangible memorial scheme to mark the miscarriage in some cases. And so it's important to know what it is that your clients want to get out of the process. Financial redress is extraordinarily important. Some people, and this has happened with many sub-postmasters, were left in terrible financial conditions because of the way that the post office had acted towards them. And again, I make the point, an inquiry might not necessarily know what the objectives of your clients are. So you have to use an opening speech to indicate and signal what it is that you want to get out of this out of the inquiry process for your clients. Access to records is important. Many children in care, for example, wanted their records of their childhood restored to them, and they've been told, oh, lost in a flood, that kind of thing. They didn't believe it, and they wanted their lawyers to push that for them. There can often be data deserts in the COVID inquiry. Some groups who were potentially vulnerable were left off national data. I'm talking about gypsies and travellers. So again, it's important to know what issues affect your clients. Many clients will have an altruistic motivation in giving evidence, in getting involved in a public inquiry. They risk re-traumatization, having to relive the past, but they're prepared to do that because they want to ensure that the next generation of individuals who could potentially be vulnerable to the same abuse or oppression don't have to go through what they went through. So again, it's important when looking at the disclosure, the vast amount of disclosure, to know what it is you're looking for. Achieving justice is important, and Section 2 of the Inquiries Act says that an inquiry panel can't rule on and has no power to determine any person's civil or criminal liability. But the panel isn't to be inhibited in the discharge of its functions by any likelihood of liability being inferred from the facts that it determines, the recommendations that it makes. So again, although an inquiry can't make findings, you can push that. You can push culpability within a public inquiry. If we could go to the next slide then, please. As I've said, opening submissions are important. I've said what the inquiry rules say about that. When making opening submissions, it's important to highlight the client issues and the objectives. I've gone through some, but it's obviously not an exhaustive list. And it's important that victims and survivors, they have an important role in shaping an inquiry. And I repeat the point, an inquiry might not necessarily know until the opening speeches are made what are going to be the issues that are going to be important. Moving to the next slide then, please, and I'm conscious of the time. In relation to, yes, if we go on to the next slide, please, Hilary, thanks. The Rule 10 process is very important. It is the means by which questions are asked. And it's not necessarily questions that you as the solicitor or the barrister representing a client will ask. It is the questions that the inquiry lawyers will ask if they don't give you permission to ask it. And so the process is normally counsel to the inquiry will ask questions. The chair can direct a recognised legal representative to ask questions themselves where appropriate. And we saw it a lot in the Post Office inquiry, where barristers such as myself got to ask a lot of questions, but we didn't see it in the child abuse inquiry, where pretty much everything went through counsel to the inquiry. So different inquiries will apply different approaches. A core participant can apply to ask a question and must set out the issue, and if it's a new issue, why it should be permitted. And the key point when drafting Rule 10 questions is to set out why it's relevant to your client. Go to the next slide, please. So in relation to, well, we move along to the next one, actually. So in relation to Rule 10 questions, the inquiry will oppose a deadline by which Rule 10 questions are to be put in. It's often 14 days before a witness gives evidence. The questions are put in on a prescribed form. The inquiry will provide responses to those questions, often very shortly, sometimes even the day before a witness attends. And what they'll say is, counsel to the inquiry will ask the questions, or will deal with the matter raised more generally. It will say that a CP representative is permitted to ask the question, or it will say whether the question is not accepted. Now, if you've got a question and it's refused because it's said not to be relevant or for other reasons, there is a facility, a procedure to make an oral application to the inquiry chair at the hearing to ask a question that hasn't been accepted. I have to say this is a very, very rare occurrence. Very often, if a question is relevant and it's refused, it's because counsel to the inquiry will be covering it themselves. Can we move to the next question, please? So coming towards the end, the Rule 9 process is important, because Rule 9 is the process by which the inquiry obtains evidence from witnesses or other individuals. So the inquiry would send a written request asking for a witness statement or a document. They can do it in relation to oral evidence as in addition. If we could go to the next slide, please. And the inquiry has powers under Section 21 to compel compliance with a Rule 9 request. I think Fiona dealt with 21 very briefly. If you're representing someone and they say, well, this individual was very important in what happened to me, and this individual is still around, I want that person to be called. It is a good idea to let the inquiry know by contacting the inquiry legal team that this is a person in respect of whom it might be a good idea for a rule turn request to be made, or if your client themselves, if they want to give evidence, it's a good idea to let the inquiry know. Very often the inquiry will have a good idea as to what witnesses it needs to call, what documents it needs to obtain. But it's not a good idea always to assume that they know everything. They haven't got the benefit of close contact with clients, so do let them know. If the inquiry accepts what you say, that so and so should be given evidence, should be requested to produce documents or give evidence, or that your client wants to give evidence, then Rule 9 is the process by which that will come about. If we go on to the next slide, please. So closing submissions, again, another very important tool to assist in getting your clients' views across. I would say always ask for specific findings on the evidence, always ask for specific recommendations, refer to the terms, the TORs, the reference terms, because an inquiry chair will be reluctant to stray too far outside their terms, and put forward your instructions from your clients on the issues and the evidence. One of the things that I was first told in the child abuse inquiry back in 2018 when I started is that the position of victims should be front and centre of the inquiry's consideration. I think that's a very good guide, and if you are representing victims, it's important that you do all that you can to address their issues and their concerns, notwithstanding the fact that you may be faced with 2 football pitches worth of disclosure. I hope I haven't gone on for too long. I think that's the end from me, so I'll pass you back to David now.
Thank you very much indeed, Chris, for that tour de force of inquiry process and procedures. That was really fascinating. I learned a huge amount. I've got a couple of quite interesting questions, which if I don't get a chance to ask you today, I'll probably come and bend your ear about at some date in the future. It was really, really useful. Thank you so much. Well, everybody, I hope you found that so far a useful and informative set of talks. I certainly have. I've learned an enormous amount from each of our 3 speakers. We've got a question on the question and answer bar, which I'm going to put to the panel now. And I think I know who it's probably directed at, and indeed she had taken herself off mute a moment ago.
Sorry, yeah, I'm here.
And the question is, because it relates to one of the topics that Fiona was covering, would it be possible to clarify why NAO, that's National Audit Office, reports are arguably covered by parliamentary privilege? A really good question, I think.
It
Fiona,
is.
can you cast any light on that?
Well, I say that simply because I've been in encounters. Well, the National Audit Office, the NAO reports, the Auditor General is part and parcel of Parliament. It is a parliamentary office. He is a parliamentary office. He is not a member of the executive. So I think the argument from Speaker's Council goes, those NAO reports, in terms of, I think, you know, they are published, they are in the public domain. So the inquiry has no problem getting them by way of disclosure. The question is whether or not you, in any witness statements you might provide for the inquiry, in reality can rely upon them or can discuss them. And certainly my understanding from discussions I have had with Speaker's Council in the past, obviously it varies, is that they considered that because of the role of the NAO and because of those factors, those reports were arguably covered by parliamentary privilege because they are part and parcel of Parliament discharging its role. Now, I think you could have quite a good discussion about that because I think they undertake an administrative role. They are not proceedings before Parliament. They are a mechanism by which Parliament holds the executive to account. On the other hand, so that's the why I don't think they're covered. On the other hand, they are commissioned by Parliament. They are used in exactly the same way to hold the executive to account. They are part and parcel of parliamentary procedures. So arguably you can't impeach or argue with them. But I mean, I think there's all to play for. I know that Speaker's Council, I think, has taken that perspective in some public law cases as well, because this is something which doesn't just come up in inquiries. It also comes up in public law cases, both if you're representing central government and individuals, in terms of what material you can rely on. So select committee reports are definitely covered by parliamentary privilege, and I think probably Speaker's Council would say that NAO reports are the kind of auditor's equivalent of that. But I think you could have a fight about it. The question is whether anybody ever would, especially as the reality is you can get the information in another way.
That's really helpful, Fiona, and that I have to say tallies with my experience and kind of instinctive reaction as well. I mean, I've got quite an interesting case at the moment in the Investigatory Powers Tribunal, where there's a bit of an issue bouncing about, which we've also had in some civil proceedings, straight civil proceedings, about whether reports of the Intelligence and Security Committee, which is quite an unusual beast with a sort of statutory footing to it, is caught by Article 9, and the position it appears is that it is. Their reports are caught, and that appears to be Speaker's Council position, but it's all sort of a little bit up in the air. It's quite, I think generally the Office of Speaker's Council tends to take quite a broad approach to that question, and tends to bring quite a lot within scope. Some things which aren't always sort of instinctively appear to be caught, but certainly the approach is
because I would sort of argue, I mean, just to sort of follow up, I would argue that the Intelligence Security Committee, not really because it's on a statutory footing, but because its proceedings cannot be impeached in Parliament because they're not really discussed. That's the very reason why it has to go to the Intelligence and Security Committee, because in a way you can't have that kind of open debate in Parliament about anything other than potentially the principles which underpin it, and or if the Intelligence and Security Committee decide to publish information. But other than that, it's a secret private thing, so why should it, you know?
I mean, you're right. The closed element makes it very interesting. I mean, they do publish public reports.
Yeah, they do.
The open version, the closed version stuff. But it makes it quite. It adds an extra layer of difficulty to it. I think that's really interesting.
Yeah,
that's really helpful. Thank you, Fiona. We've had another question, which I'm going to throw out to the panel as a whole to get your collective view on. I've got a view about this. But your experience across the panel will be much more telling, I think. And the question is this: has the chair of an inquiry ever expanded the terms of reference during the course of the inquiry? And I suspect the answer to that may bring in some issues about who sets terms of reference and how they can go about being expanded, and what to do when a chair steps outside, it would seem, the boundaries of the terms of reference. So would any of you like to speak on that issue? Chris has taken himself off mute, so I'm going to grab him straight away.
It's very difficult for a chair to do that. The terms are set at the outset of the inquiry. They are the basis upon which an inquiry proceeds. The chair can sometimes stretch the terms of reference, and can be quite sort of generous in doing so, but I'm not aware of any case where terms of reference have been reset or have been expressly, stepped out of. I don't know what your experiences will be, Fiona and Katharine.
Mine have only ever been of people asking for exactly that to be done, and I think a very obvious example is there was a great deal of pressure for the COVID inquiry to include all of the PPI contracts issues, which I think were expressly carved out of it, and deliberately so. So no, I haven't ever experienced it actually happening.
I think in the past 10 years, I don't think it's happened. Because the terms of reference are nearly always drawn in an unbelievably broad way. So you can pretty much read them as whichever issue it is that comes up. Usually it's subsumed by what is usually a very, very broad, often so broad that they're almost meaningless, terms of reference. Obviously, you would be able to do it but obviously you would have to go back to the minister. The minister would have to then agree to amend the terms of reference. There would then because these days terms of reference are the subject of public, not necessarily public consultation, but often consultation with those who have been most impacted, you would then probably have to reconsult under, you know, a common law duty. There's no statutory obligation to do so. So it would add a layer of complexity. So I think probably most chairs would say, no, we're not going to amend, but we might include X. The only time I could imagine it happening would be if something happened during the course of the inquiry. For example, there was the collapse of a criminal prosecution, for example, in the post office case, which went on in the middle of the inquiry. You would then probably undoubtedly wouldn't be able to stretch the terms of reference, something like that.
That's really helpful. I think, I mean, I imagine if a chair did step clearly outside the boundaries of the terms of reference, he or she would be judicially reviewed quite quickly by one of the parties. I mean, certain, and I think you're right, Fiona, about the sort of in practice, what tends to happen is people try and get themselves within the scope of broad terms of reference. I mean, interestingly, from the other side, I've advised in the past on the setting of terms of reference for inquiries, and there it's quite interesting seeing it from the other position, because sometimes a particular sector of the state will see coming down the tracks an issue that they would like to try and avoid having debated at the inquiry, perhaps a wider policy issue.
Yeah.
And there will be great taken over sculpting the terms of reference so that they are broad enough to make it a real and valuable inquiry, particularly if, for example, Article 2 is engaged, whilst at the same time not opening the floor to endless sort of policy debates about other issues of public life, which, whilst perhaps very valuable, are not really what the inquiry is sort of set up to deal with.
I think it's very difficult, though, because core participants who often represent either bereaved groups or victims, they want to discuss the broader policy issues. They want to know what happened in their particular case, or what happened on the day, or why these things happen. Yeah. But they want to know why these things happened in a broad policy context.
Particularly if it's seen that the broad policy context is actually part of the reason.
Yeah, well, exactly. So, you know, Grenfell's the classic example about that. You know, why did the building burn down? At least in part because of broader issues to do with outsourcing, to do with building safety regulations, you know, all those sorts of things.
Yeah, I think that's absolutely right.
I think that Fiona's right. I agree that the terms of reference will be drawn broadly, and it's just a case of giving a wider interpretation if issues arise. But I don't think a chair would ever step outside, because, as David says, that's that's a whole new ballgame in terms of being potentially judicially reviewed.
Yeah, fast track to judicial review, I think, on that. Yeah, and while Chris has still got his, he's turned his microphone.
No, I'm back.
I'm back on again now. A question I had for Chris, if I can, you talked about the Rule 10 process, and I was interested in that. You obviously said the key thing is to explain why a question you're proposing is relevant. I mean, the last public inquiry I appeared at was the Cranston inquiry. Now, that was non-statutory, and the arrangement there was that all questions would be asked by counsel to the inquiry. So there was a process for participants to ask counsel to the inquiry to ask questions on their behalf and to raise them, but the questions would still be asked by CTI. Now, in fact, in practice, I think most of the proposals, if not all the proposals, were not taken forward. But when you're framing your relevance pitch, if you like, in your request that you have an opportunity to ask questions or the questions be put on your behalf, do you have any practical tips for how to really engage with that and how to land a blow, if you like, that will mean CTI thinks, yes, actually, we do need to take that forward?
I think you can point to inconsistencies with what witnesses have said. So if someone is saying something that's not consistent with someone else, then you can say that needs to be clarified. I think if there is an issue that is fundamentally important to your client and comes within the terms of reference again, then you can frame it as something that is significant and substantial and needs to be asked. Very often, CTI will have it in mind to explore the topic, but they're not necessarily going to explore it in the way that you want them to. So quite often you get a response which is CTI will cover this. But what you've done is you've made sure that when CTI covers it, they've covered it in the way that you want them to, not necessarily the way that they might have otherwise have done without the Rule 10 input.
That's really helpful. Thank you, Chris. I've just got two other questions I wanted to put if I could. One, I think is probably more a question for Katharine, which is this, and it's sort of inspired by the article we wrote about the Hillsborough duty. I just wondered what your thoughts on this were. Obviously, as you indicated, things have fallen away slightly. It was a really big pitch, I think, from Keir Starmer when he first came into power. He was going to have a law for Liverpool. Speaking as a Scouser, I was quite interested in that. And he made a lot of that. And as you indicated, I think the proposal was that would be there, at least in draft, before the latest anniversary. And it's not. And obviously, there's been some commentary on other papers. The Andy Burnham proposals, though, which gathered a lot of attention over the course of the last few years and have been examined, as you said, by a number of organisations, including the Parliamentary Joint Committee on Human Rights. Did you have any sort of views about whether, about sort of workability of any of those proposals? Is there anything you can sort of cast light on in that respect, do you think?
I think, for me, the problem that there are two main problems for me looking at it as someone who would be, if it came into effect, say, would be advising on it and also representing people in courtrooms, is firstly, public sector bodies are involved in almost everything I do in one capacity or another. So in the Court of Protection, you've got local authorities, you've also got the official solicitor, which is a public body, you've got the Office of the Public Guardian, also a public body, you've got ICBs, you've got NHS trusts. They are all involved in different ways. There is an existing disclosure regime in the Court of Protection, taking that as a practical example. How does this intersect with that? Because the Court of Protection, while it is a civil proceeding, is not adversarial, or not supposed to be adversarial, although it can be. How is it going to work? Is this going to be an additional thing that they have to do, or is it going to be, this is your disclosure obligation, rather than it overtakes the sort of civil regime? Because the whole point of duty of candour is that it operates where civil proceedings disclosure was not considered necessary. You didn't need it. So in realms where it's already extant, I kind of don't see why we need that as well. Whereas in inquests and inquiries where there's less consistency and less clarity, and there are problems with the existing framework because it's got a lot of discretion, it's got a lot of potential for differential outcomes, I can see it more there. So I do think they need to think about confining it more, but that is going to be controversial because none of these proceedings exist in a vacuum. And then the second one is it actually going to make it better for the people who want it, which is the victims and their families, survivors' families? Because if what we end up with is a very broadly defined duty of candour, which is what the Burnham Bill said, that is all going to have to be litigated for us to work out exactly what it means. And if people who are feeling that it's not being interpreted in the way they want, don't have legal representation, aren't like us able to listen to all of this and take it in and automatically know what our options are, is it actually going to make any difference? Or is it just going to be another statutory regime that kind of is falling down at the first hurdle? Because the NHS statutory duty from 2014 is so badly functioning that it is being reviewed already, and we're only 11 years down the track, because the compliance, the concerns about compliance, there are concerns about how much it's actually changed stuff, there are concerns about the impact it's had on NHS culture, and that's not good, and that was the precedent for the 2017 bill. So I think there is something that could be done. We have public sector wide duties, we have the PSED, but it doesn't exist in a vacuum. It's in a very complex legal regime, and it recognises the boundaries of its sort of role and its potential. So I think if I were the parliamentary drafts person, that is what I'd be thinking about, is what will this practically do? And are the problems that I create by doing it this way going to be more than the benefits? Because ultimately this needs to deliver benefits if anyone's going to be happy with it. That was a very long answer to your short question, David.
Not at all. It's an excellent answer and really, really informative. That's why I asked you about it. I thought you would have something to say about that. Thank you very much indeed, Katharine. Well, we've run over time a little bit. I'm going to ask one final question and then wrap it up for the day, if I may. It's a short one. I just wonder, and this may be one more for Chris or Fiona, given the content of your talks, I wonder what the consequences are of a breach of the confidentiality undertakings that I think Chris was mentioning before in a public inquiry. I wonder if either of you have anything to say about that.
Well, it would be a contempt of court. Now, the chair of the inquiry doesn't have power herself to him or herself to, in effect, sentence for that breach. So what you would have to do is issue proceedings for contempt of court in the High Court using the contempt regime as set up under the CPR, and bring proceedings. Now, what I can't remember off the top of my head is whether or not you have to check with the Attorney General. Sometimes when you're bringing claims for contempt, in these circumstances, you have to check and get the say-so of the AG to do so. I can't remember off the top of my head whether that is the situation here. I can always go away if somebody's particularly interested, send me an email and I'll go and look it up. But that's what happens. I am not I think there has been threats of that. And if I remember rightly, I think the Reverend Ian Paisley may well have either been convicted or certainly prosecuted for contempt of court, I think, for not answering questions in the context of an inquiry, and one of the inquiries to do with Northern Ireland.
Yeah, that's really helpful, Fiona. That's my understanding, I think, as well. And I know there are issues around Johnny Mercer as well, refusing.
Yeah, in the Afghan inquiry, yeah, about him not saying who it was who blew the whistle.
That's right.
About the SAS, yeah.
Yeah, that's right. Exactly.
Yeah.
Fantastic. Well, thank you very much indeed. I've got an eye on the time. I'm conscious that we've run over a little bit. I'm very grateful to all attendees for still being with us now. Thank you for listening. I hope that's been an informative and interesting set of papers. I found it fascinating. I've learned a huge amount. Can I say a huge thank you to our three participants, Fiona, Chris and Katharine. Thank you very much indeed for your papers. And it just remains for me again to thank everybody for attending the seminar, and say that I hope you'll come back for the third seminar in due course, and indeed for any other landmark training events that you may find useful. So thank you very much once again, and good night.
Thank you, David.
Thank you.